Yeah, a lot of clients ask me that, and they say, okay, because they'll come in and they say, well, I need a trust. And well, it's not just a trust that you need. There are other documents that go along with it. So really, what compromises a proper estate plan? Obviously, there's the trust, okay? And people understand, the trust is the legal document that says, this is how my assets during my life are going to be managed. If I'm not able to manage them and I'm disabled, here's how they'll be managed during my period of disability. Ultimately, when I pass away, here's how they'll be managed for my children, and then ultimately distributed to my children. So that's the document that people refer to as the trust, and they think, well, that's what I need, a trust. But there's more that go along with it. The other documents that go along with it that comprise a proper estate plan, the second one is a pour-over will. People say, what do you mean, what's a pour-over will? What's the difference between a will and a pour-over will? Well, ideally, when you're setting up a trust-based plan, you're cutting out the probate courts. So a pour-over will basically acts like a safety net. If, for instance, you forget to put something in your trust, so you have something in your estate when you pass away and it's not in your trust, the pour-over will captures it and pours it over into your trust. That's why they call it a pour-over will, not some fancy legal term. It's a practical name. That's the good news. Right? It pours over into your trust so that you know the trust is indeed the dispositive document to handle all of your property. But for it to pour over into your trust, guess what? You've got to go see a probate court judge, because that's who's going to give you the order to pour it over into your trust. That's the bad news. The good news about that is it's an abbreviated procedure. It's just a motion procedure where you submit the will to the probate court judge, you submit the asset and say, so-and-so just forgot to put this in the trust, and it's an abbreviated procedure. So it's not as long and drawn out as a full-blown probate. It's a lot simpler, but you still have to, it's a little bit of a delay to capture the asset. So second document, pour-over will. Third document is the financial power of attorney. Again, assuming something happens to you, you are not killed in an accident, but you're disabled. Well, who gets to make financial decisions for you and pay your bills? That's what the financial power of attorney does. It puts an agent in charge who's going to step in and manage your finances in the way that you want them managed. Most lawyers will use something called a uniform statutory power of attorney, which is basically like a blank check. Okay? So if you've drafted this really good trust that's got all these neat terms and conditions about how your property is supposed to be managed, and then you've got this financial power of attorney that essentially says, this is the person who's going to manage my assets in the event that I can't, but don't give them any instructions, basically just giving them a blank check on the one hand, and on the other hand, they're also the successor trustee of your trust that says, wait a minute, here's how the assets are supposed to be managed. So in our case, the financial power of attorney that we use actually incorporates the terms and conditions of your trust so that the two documents work consistently hand in hand. And that's not any kind of a legal mumbo jumbo thing. That's just as a practical, common sense approach. Those two documents should work together hand in hand. And I got to tell you, a lot of times they don't. So that's the third document. The fourth document is your healthcare agency. Now, your healthcare agency is designed to put someone in place to make healthcare decisions for you in the event that you can't make healthcare decisions. And that may sound, simple enough. There's things that are in your healthcare agency, such as, do you want organs to be donated or not donated? Under what circumstances do you want organs donated? Are they just to be donated for transplant to someone else? Are they to be used to conduct research? You can specify exactly whether or not you want organ donation and the terms and conditions of what organ donation you want to have, whether it's to be research, scientific, to a specific donor. Also, in your healthcare agency, that person is designated as the one who has the authority to dispose of your remains. So if you want to be cremated, if you want to be buried, if you want your ashes scattered at sea, that person has that authority under your healthcare agency to make that decision for you. So the healthcare agency will come into play again. If you can't make those decisions for yourself, that person will step in and make those decisions for you. Now, the fifth document is the living will, which directs, what kind of life support can be withdrawn or not withdrawn. If your choice is to have life prolonged, well then the living will dictates that they have to, administer every kind of life-saving mechanism known to accomplish that. On the other hand, if you want, life support withdrawn if there is no brain activity, that document gives the hospital and the doctor the authority to do that. So then when you consider those 5 documents together and you understand how they all work to make sure they're all coordinated together, you understand why those 5 documents do in fact constitute a proper estate plan. In my office, we actually do take it one step further. I have a separate document that I use that you designate that person who is going to be in the healthcare agency to dispose of your remains. I have a separate document giving that person specific instructions as to cremation, burial, or are ashes to be scattered at sea or to be scattered someplace else. Here in San Diego, we have a lot of military personnel, and it's very important to a lot of military personnel to have a military funeral, so we plug that in. I learned from clients of mine, 2 retired Navy nurses, that the Navy has a burial at sea program. Not only do they have a burial at sea program, the urns that they use are biodegradable. And so I can spell that out in this form if that's important to someone. And I think if it's important to someone, I want to know about it and I want to be able to address it so that their family knows, oh, here's what he wanted or she wanted, let's make sure we do this. And there's a document in place that spells it out. A lot of older people may have incorporated Neptune Society, for instance, which is a service that will scatter at sea. And they have a contract number. Or they've got, pre-need arrangements that they've made with certain mortuaries. And again, they've got a contract number. I plug that into that document so that the family knows, oh, it's done for them. So when and if the time comes, everyone is upset that you've lost someone, but at least there's instructions there. Oh, this is how it's already taken care of. Think of the burden that takes off of everybody, that you've had the foresight to do that for them. So, in terms of doing a proper estate plan, those are the documents that comprise a proper plan. That's the one extra document that I sort of add to it for that reason. And, hopefully that's what we accomplish for people. To have a proper estate plan, you basically need 5 documents. You need your trust, you need a pour-over will, you need a financial durable power of attorney, a healthcare power of attorney, and a proper living will. And when you have those, you'll have a proper estate plan. And if you want to consult with me to make sure that you have that kind of a plan in place to protect your family, there's a link at the bottom that you can contact me. In the event that you're adamant about trying to do this yourself, because there are a lot of do-it-yourself people out there, there's another link that if you want to give it a go, it's another website that will take you through a question and answer period that will help you draft these documents on a more formal basis.